Hello dear students, I am Dr. Prinpreet and today I am back again to talk to you about the second part of the topic establishing property rights. Now at the introduction, a specific kind of property rights known as intellectual property rights, IPR if you've heard of, protects the works of art, literary and creative compositions, inventions and trademarks. In the knowledge economy, intellectual property rights are vital for fostering innovation, creativity and economic expansion. The process of establishing intellectual property rights is essential for enabling the firms, the inventors and the creators to safeguard their ideas, inventions and discoveries. Trade secrets, literary and creative works, inventions and trademarks are just a few examples of the intangible assets that are legally recognized and protected by intellectual property rights. Creators and innovators are granted exclusive rights to their ideas through intellectual property rights, giving them the ability to manage how their works are used, distributed and commercialized. By granting a temporary monopoly that allows the artists to recover their costs and make money from their work, these rights encourage innovation. IPR promotes innovation and creativity, which are essential for the development and economic success by securing these rights. Since others may simply replicate their creations and benefit from them without permission, inventors could be less willing to devote time and resources to producing new innovations or artistic works in the absence of such restrictions. Intellectual property rights are governed by international agreements and treaties such as the Paris Convention for the Protection of Industrial Property in 1883, the Berne Convention of the Protection of Literary and Artistic Works of 1886, the TRIPS Agreement, that is TRIPS 1994 under the WTO, the Patent Cooperation Treaty PCT 1970 and the Madrid System for the International Registration of Marks 1891. These agreements establish common standards for IP protection and facilitate enforcement across the borders, ensuring that IP rights are recognized and protected in various countries. Now, let us talk about the types of IPR protection and the policy framework which is attached to them. The protection of intellectual property within the national borders is governed by the legislation of each individual nation. These regulations specify the requirements for acquiring intellectual property rights, the length of protection and the potential legal recourse in the event of violation. Although it varies amongst states or nations, the legal foundation for intellectual property rights often consists of the following important elements. Patents. It gives the innovator temporary exclusivity on their inventions and technological advancement. For a finite period of time, often 20 years, patents protect inventions and innovations by giving the inventor the only authority to produce, use, sell and distribute the innovation. By enabling innovators to make money off of their inventions, patents promote innovation more. The prerequisites for receiving a patent, which include innovation, non-obviousness and industrial usefulness, are outlined in the national patent laws. The extent of protection, the steps involved in submitting an application and the responsibilities and rights of patent holders are all outlined in the patent laws. Second category is the trademarks. The brand names, logos, symbols and other identifiers that set the products or services apart in the marketplace are protected by trademark law. Trademark protection guarantees that companies may create and preserve their brand identities while also assisting in preventing customer confusion. The procedure for registering a trademark, the requirements for registration and the protection afforded to registered trademarks are all outlined in the trademark laws. The processes for resolving trademark disputes and upholding trademark rights are also established under these laws. Third in this category is the copyrights. Original works of authorship such as literary, artistic, musical compositions, etc., are all safeguarded by copyright laws. These legal protections grant the creator the sole authority to reproduce, distribute and perform their original literary, artistic and musical works, the rights of the copyright holders, the length of protection and the exclusions and restrictions on copyright protection are all outlined in these laws. Depending upon the jurisdiction, copyright protection usually lasts for the creator's lifetime plus an extra 50 to 70 years of protection. One more type in this category of IPR is trade secrets. Trade secrets safeguard exclusive corporate knowledge including algorithms, procedures and tactics that provide an edge over the competitors. Trade secret laws enable the companies to pursue legal action against people or organizations that misappropriate or divulge trade secrets without permission, thereby protecting sensitive company information. As long as the information is kept private and not made public, trade secrets are safeguarded. Then there is one more type of IPR in this category, that is the design rights. Design laws give the design owner exclusive rights to preserve the product's aesthetic appeal. These rules outline the requirements for gaining protection for the designs as well as the extent and duration of those rights. These safeguard the product's shape, the color, its texture as well as its overall visual appeal. The owner of the design has the only authority to use it and market it. Now, what is the impact of intellectual property rights on the economy? I will talk about it very briefly. Because intellectual property rights affect market dynamics, competitiveness and innovation, they have a big economic impact. IPR promotes investment in research and development by offering exclusive rights which results in the development of new goods and technology. IPR, however, can sometimes result in market monopolies, restricting access to necessary products and services, especially in industries like software and pharmaceuticals. Now, I will be discussing the global obstacles that we face with regards to IPR enforcement. Global intellectual property rights enforcement is fraught with certain difficulties. One amongst them is piracy and counterfeiting. IPR is undermined by the pervasive availability of pirated digital content and counterfeit goods, which cause large financial losses for the firms and the creators. International disparities are also one of the problems. The businesses confront differing degrees of protection in different markets due to variations in IPR enforcement across nations, which poses a hurdle to global trade and investment. One more problem here is the access to medicines. The high price of patented medications has sparked discussions about how to strike a balance between encouraging innovation and guaranteeing that everyone has access to the necessary medical treatment, especially in the poor nations. Now, talking about balance between innovation and public access, how the IPR debate goes. The argument over intellectual property rights centers on striking the correct mix between promoting innovation and guaranteeing the general public access to information and technology. Some thinkers contend that the existing intellectual property rights system unduly benefits the big businesses which drives up the cost and restricts the access to necessities. Some others argue that robust intellectual property rights are essential for stimulating innovation and promoting economic expansion. To develop an IPR framework that fosters innovation and the general welfare, policymakers must balance these conflicting goals. Now, let us take a look at the significance of property rights in case of environmental protection. Property rights have a significant impact on how natural resources are used and maintained, which helps to conserve the environment. While poorly defined property rights can contribute to environmental degradation, well-defined rights can encourage the sustainable use of resources. One point that highlights this significance is management of sustainable resources and property rights. Property rights are necessary for the sustainable management of resources because they encourage private and public investment in conservation. Owners are more inclined to manage resources sensibly when their property rights are protected, since they stand up to gain in the long run from their actions. If private landowners are certain that they will continue to own the land, they might, for instance, invest in reforestation or sustainable agricultural methods. Property rights and common pool resources. In the absence of clearly defined property rights, common pool resources such as fisheries, forests and water sources are especially susceptible to abuse and degradation. By coordinating private property ownership or group management, private rights can help avoid the tragedy of the commons by bringing individual incentives and sustainable resource usage into line. On the other hand, community participation in decision making and close attention to local conditions are necessary for the effective management of common pool resources. Now, how we use property rights as a tool for protecting the environment? Because they offer a legal foundation for stopping pollution and preserving the natural ecosystems, property rights can be an effective instrument for environmental conservation. Conservation easements, for example, provide landowners the ability to limit development on their holdings while preserving biodiversity and ecosystems. Furthermore, as property rights allow people and groups to sue to defend their properties from environmental damage, they can also be utilized to hold polluters responsible. Now, what are the problems in enforcing environmental property rights into practice? It can be difficult to implement environmental property rights in places with poor legal systems, like I discussed earlier, with competing land claims or little funding. Furthermore, balancing the interests of various stakeholders such as landowners, local communities and environmental organizations may be necessary for the enforcement of environmental property rights. It takes a combination of legal, economic and social tactics that support sustainable development and conservation to ensure the achievement of environmental property rights. Social stability and property rights. Due to the fact that property rights offer the legal framework for settling the disputes, averting conflicts and advancing social order, they are intimately associated with social stability as well. Because they guarantee that people and communities may access resources and defend their livelihoods, secure property rights promote social cohesiveness too. The foundation of property rights for social order. Due to their definition of resource ownership, use and transfer, property rights serve as a foundation for social order. People and communities can participate in economic activities with confidence when property rights are well defined and upholdable, as they will know that their rights will be safeguarded. Through the elimination of uncertainty and the avoidance of resource related conflicts. This promotes societal stability. Social unrest and insecure property rights, the effect of this. Social unrest can also result from insecure property rights because people may use violence or other types of confrontation to defend their claims. For instance, land disputes in rural areas have the potential to intensify into larger conflicts, especially in areas with weak judicial systems or a history of complaints. Maintaining calm and averting social turmoil requires protection of the property rights. Now, property rights and dispute settlement, let us take a look at this. Because they offer a legal framework for resolving disputes over resources, property rights are essential to conflict resolution. Property conflicts are frequently resolved through mediation, arbitration and litigation. The results of these processes are enforced in large part by legal institutions. Establishing or restoring property rights is frequently a top priority for re-establishing social stability and spurring economic growth in the post-conflict cultures. Property rights in societies after the conflict. Property rights sometimes cause conflict in post-war countries because displaced people typically return to regain their resources or land. In these situations, re-establishing property rights necessitates giving considerable thought to the past wrongdoings, intricate legal issues and social relations. Property rights changes in post-conflict environments are frequently aided by the international organizations and the non-governmental organizations, that is the NGOs, which lay the groundwork for sustained peace and stability. Now, what is the role of property rights in fostering social harmony in the future? The ability of the property rights to further social harmony will depend upon the ongoing initiatives to fortify legal frameworks, provide fair access to resources and rectify the past wrongdoings. Property rights will become more crucial in averting conflicts and fostering social stability as global issues like urbanization, migration and climate change keep worsening. Property rights must be given top priority by the policymakers as a crucial element for peace building and social cohesion initiatives. Now, let us take a look at the steps that are involved in creating intellectual property rights. The identification of intellectual property, the application for protection and the enforcement of the rights are some of the procedures involved in creating intellectual property rights. How are these intellectual property rights established? Identifying the intellectual property that needs to be protected is the first step in creating the intellectual property rights. This entails figuring out which kind of protection is best and whether the intellectual property is protected at all under the applicable laws or not. Now, filing application for protection of intellectual property, what is the process? The next step is to submit an application for protection to the relevant intellectual property office when the intellectual property has already been identified. Depending upon the jurisdiction and kind of intellectual property, different application procedures may apply. Intellectual property protection involves filing an application with the appropriate office. Patent applications are filed with the National Patent Office or through an international system like the PCT, requiring a detailed description of the invention, the claims and the drawings. The Patent Office examines the application to determine if the invention meets patentability requirements, and if so, it grants the inventor its exclusive rights. For trademark applications, these applications are filed with the National Trademark Office or through an international system like the Madrid system. The Trademark Office examines the application to ensure that it is distinctive and not deceptive and not confusingly similar to the existing trademarks. If the trademark meets all requirements, the owner registers the mark, giving the owner exclusive rights to use it. Copyright registration is filed with the National Copyright Office and the creator files a copy of the work. Trade secrets do not require formal registration, but businesses must maintain their confidentiality. Design rights applications are also filed with the National Design Office on an international system. Now, safeguarding intellectual property rights to prevent an unlawful use, infringement or misappropriation, the owner of intellectual property must aggressively defend such rights when they are created. The first step is monitoring and surveillance. Owners of intellectual property need to keep an eye on the market for any possible violation of their rights, to find instances of unauthorized usage of their intellectual property. This may entail hiring the investigators, utilizing watch services or performing routine searches. Second, letters of cease and desist. When an infringement is discovered, the owner of the intellectual property may demand in writing that the infringer ceases using the work and take corrective action by sending a cease and desist letter. When trying to settle a disagreement without going to the court, a cease and desist letter is frequently the initial move. Third option can be litigation. The owner of intellectual property may initiate a lawsuit to enforce their rights if the infringer ignores the cease and desist letter or if the disagreement cannot be settled amicably. Several remedies such as injunctions, damages and the destruction of infringing items may be obtained through litigation. One more alternative here is the alternative dispute resolution, ADR. Mediation and arbitration are two examples of alternative dispute resolution techniques that may be used to settle intellectual property conflicts. ADR can be a less costly and a speedier alternative to litigation for resolving the disagreements. Then there can be a global monitoring. It can be difficult to enforce intellectual property rights across the borders, particularly when dealing with cross-border infringements. Intellectual property rights can be enforced internationally through procedures provided by international accords like the TRIPS agreement. However, enforcement can still be complicated and remain resource intensive. Now, what are the difficulties in creating and upholding intellectual property rights? Creating and upholding intellectual property rights is also a difficult process with many moving parts, especially in a technologically advanced globalized world. The first difficulty that we face is globalization and transnational violations. The ease with which intellectual property can be reproduced, distributed and moved across national boundaries has made the establishment and enforcement of intellectual property rights more challenging as a result of globalization. In order to effectively combat cross-border infringements such as online piracy, counterfeit goods and patent disputes, government and international organizations must coordinate their efforts. Second step can be technological progress. New obstacles to the protection of intellectual property have been brought about by technological developments, including the internet, digital technologies and biotechnology. There are now gaps in protection and enforcement because the quick speed of innovation has surpassed the capacity of legal frameworks to keep up. For instance, copyright holders now face serious challenges from digital piracy and online infringement, and patenting cutting edge innovations like gene editing and artificial intelligence presents difficult moral and legal dilemmas as well. One more problem that we come across here is balancing the private and public interests. The interest of innovators and creators must be balanced with the larger public interest through intellectual property rights. Intellectual property rights can limit access to knowledge, technology and necessities while simultaneously encouraging innovation. Pharmaceutical patent protection, for instance, might restrict access to life-saving medications, sparking discussions about mandatory licensing, patent pools and the availability of necessary medications. Obstacles that are related to law and regulation can also be one more problem in this direction. Businesses and innovators trying to establish and protect their rights in various jurisdictions face difficulties due to the vast differences in the legal and regulatory framework around intellectual property across the nations. Variations in procedural requirements, legal standards and enforcement methods can lead to ambiguity and raise the price of acquiring and defending intellectual property rights. The fifth problem here is rights to intellectual property in the developing nations. There are particular difficulties in establishing intellectual property rights in the developing nations, such as inadequate legal frameworks, scarce resources and low intellectual property awareness. The need to balance the protection of intellectual property rights with the advancement of knowledge, technology and economic progress may provide challenges for the developing nations. International organizations and rich nations are vital in helping the developing nations to fortify their intellectual property systems through legal reforms and capacity building. Now, let us conclude this entire discussion. In the knowledge economy, intellectual property rights are essential for promoting innovation, creativity and economic growth. They give creators the ability to control how their creations are used, distributed and commercialized. They protect literary and creative compositions, trademarks and works of art. Each country's laws, which specify the conditions for obtaining the rights, the duration of protection and possible legal redress in the event of a breach, control the protection of intellectual property inside the national borders. Trade secrets, design rights, copyrights, patents and trademarks are all significant components of intellectual property protection. Innovators are granted temporary exclusivity through patents, whereas brand names, logos, symbols and other identifiers are protected by the trademarks. Trade secrets serve to protect exclusive company information and design rights serve to preserve the visual appeal of the product. The economy is greatly impacted by the intellectual property rights since they encourage investment in R&D, which produces new products and technologies. They may nevertheless also result in market monopolies that may impede access to necessary goods and services, like I discussed in case of medicines. Strong rights are necessary for economic growth according to some thinkers, while others contend that the current system rewards the larger corporations. Due to its promotion of sustainable resource management and prohibition of the misuse of the resources found in common pools, property rights are very important for environmental preservation as well. Nonetheless, in order to reconcile these opposing objectives and advance innovation and the general welfare, a clear IPR framework is very much required. With this, we come to the end of today's lecture. Thank you so much.